Thank you to the panel. We would now move on to the first session on apartheid economic crimes, and I would like to call to the floor Mr. Charles Abrahams, who will be speaking on apartheid state secrecy. Just some brief information on Mr. Abrahams for those attending the tribunal. He is one of the founding directors at Abraham Kivitz Attorneys and has been very intricately involved in human rights litigation in both the commercial and public interest sector. He has also acted as an expert consultant to a number of United Nations special rapporteurs, such as Professor John Ruggie, as well as Cephas Lumina.
Thank you, Mr. Charles. Could you kindly state your full name for the record?
For the record, I'm Charles Abrahams, more specifically Charles Peter Abrahams.
Thank you. You're here to speak to the role of foreign corporations in aiding and abetting apartheid South Africa. Mr. Abrahams, can you tell us a bit about your background that places you in good stead to speak to this topic?
I've been a practicing attorney for the last 21 years. As part of the fulfillment of a master's degree in public international law, I've chosen the topic, the doctrine of odious debt, and the question, posited by the thesis is: does international law provide a remedy to instances where debts are contracted for the purpose of committing recognized international wrongful acts? And my focus was specifically on the issue of the apartheid debts.
Okay, thanks. And there were some preliminary questions that were posed during the presentation of your colleague that she said you would address. Would you mind addressing those questions before we proceed with your actual questions?
So, initially my presentation was going to dovetail the presentation that Ms. Marjorie Jobson had given, as I'm also and have been the South African attorney involved in the more than decade-long apartheid litigation in the United States. And I was going to specifically focus on how the litigation had come about, the challenges that Kudumani and the Nsebesa group had faced in pursuing the litigation, and why it is that the litigation had ultimately been dismissed. However, in light of Member Yakub's last comment on making the connection between the litigation, which essentially focuses on the issue of seeking to hold, corporate foreign corporations accountable for essentially individual egregious human rights violations, and making the connection to the economic crimes. I thought that I would instead spend some time on positing the litigation within the broader context of the economic crimes that had been committed within South Africa that has resulted in a foreign debt of almost in excess of $80 billion as of 1993, of which a public debt amounted to about $40 billion, actually more. And how that debt has come about, and more than particularly the attempts that were made in order to hold those entities liable to whom that debt was owed to. And it is in that context then that the Kudumani litigation needs to be positive.
Can you tell us a bit more about the actual debt? What did it amount to, and who was it mostly owed to?
So thank you for that. So in very broad terms, perhaps what I need to do is to state that as of 1993, which was the period when South Africa was about to transition into the new democracy in 1994, South Africa's entire apartheid debt, and I'd like to confine myself to what one would regard to as the foreign debt, amounted to, close to, 80 billion US dollar. Now, it is important to remember that at the time the exchange rate between the South African rand and the US dollar was in the order of, or the region of 3.4 rand for one US dollar. The public debt component of that foreign debt was about 45 billion US dollars, and that essentially consisted of the obligations which the central government had, as well as obligations in respect of the public corporations, state-owned corporations. Most of these debts, in fact, had come about as a result of the debt standstill in the mid-1980s. You will recall that there was a major debt standstill when almost all of the banks, corporations had refused to extend credit to the apartheid regime. So I'm going to take a few steps back. South Africa in the 60s was the largest supplier, not one of the largest, then the largest supplier of gold. And so gold essentially has been the single most commodity that ensures that South Africa would continue to have a supply, an ever supply of foreign credit. It was the basis upon which foreign corporations and banks engaged in commerce with South Africa. So even then, when in 1968, when the London Gold Pool got closed down because of international economics, the Americans, in fact, sanctioned an immediate closure of the London Gold Pool, and at that time, South Africa's gold were principally marketed through the gold pool. And the reason why the Americans wanted that to be closed is simply because it could no longer defend the American dollars pegged, to the gold standard. One country that immediately rose to the occasion and its corporations was Switzerland. Immediately thereafter, 3 Swiss banks, known banks, provided the basis to market South Africa's gold internationally. And from the late 1960s throughout the 70s and the 80s, South Africa's gold, one could effectively say, had been laundered through Swiss banks to keep liquidity flows, international liquidity, to South Africa alive. That's the context with which I'd like to place out there. All of this takes place against the backdrop of numerous resolutions through the United Nations, i.e. the General Assembly, as well as the United Nations Security Council, condemning the acts, the barbaric acts of apartheid, condemning apartheid itself, and a series of resolutions got adopted. But those resolutions were not just confined to South Africa as a state, and also to other states, but they were also directed to corporate entities doing business with the apartheid regime. And so what I would like to do is just highlight some of the key resolutions that have come out from both the General Assembly as well as the United Nations Security Council. So, for instance, as early as 1975, there was a general call by the General Assembly that the United Nations Security Council adopt a compulsory oil embargo. That was followed by the compulsory, in 1977, a compulsory United Nations Security Council arms embargo being imposed onto South Africa. And that's important Because after that, no state or corporate entity were permitted to trade with South Africa insofar as it concerns arms ammunition. And yet, if we look at the presentation that had been made by Marjorie Jobson, we've seen that there were corporate entities that continued to trade, notwithstanding the compulsory arms embargo. And the reason for that is that they simply found it, that it was South Africa was the country to invest in, because the returns were too great.
On that subject, though, are you able to identify which corporations and also the extent of the foreign banks? You made mention of billions having been exchanged. What banks were involved and what was the extent of their involvement?
So, in response to that question, what I'd like to do maybe is just to set the fundamental basis and then get into the particular corporations. Now, ordinarily, when states contract loans, they do so either with your multilateral institutions, that would be your World Bank or your International Monetary Fund. South Africa being a member of both, the last World Bank fund that the South African apartheid government received was in 1976. The International Monetary Fund continued to finance the apartheid regime. In fact, in the wake of the 1976 student uprising and what happened, a loan of in excess of $400 million was extended by the IMF, which was equivalent to the increase of South Africa's defense expenditure at that time. But the IMF's funding came to an end in 1983 when the US basically enacted the legislation, I think it was called the US Grants Act, where the IMF could only extend loans with the approval of the US. The result of that was that South Africa was increasingly resorting to foreign corporations and banks for international credit. And so the simple point here is that you have a criminal enterprise that had been cut off from multilateral funding, but in respect of which foreign banks and corporations, in particular, and I will come to that, Swiss and German, were eager to fill the gap. And that essentially is the story of how notably German and Swiss banks have provided loans and credit to South African state entities, to the South African government at the time, and that enabled it to do what it needed to do. In fact, in the words of one of its former finance minister, and I'd like to quote Owen Horwood, in 1983, he said that the story of economic development of this country is intimately bound up with foreign capital, technology and expertise. Significant investments usually brings all three. It allows us to do what we want rather more quickly. It allows us to do some things better than we do otherwise. But I'd also like to quote one industry leader who said that South Africa is the great investment opportunity if you are able to withstand the political heat. So it's quite clear that, the knowledge of the type of regime they were working with, it was quite clear that there was knowledge on the part, they knew exactly the type of regime, And notwithstanding, the investment opportunity and the returns were too good. So that's the setting. And that setting I make by virtue of my own research, independent research which I've conducted, and that research is available, and I'm quite happy to make that research available to the members of the panel.
We actually will be quite happy, instead of having your whole research, just to ensure that you, when you give us a summary, you just put in the footnotes for each of the references in relation to your evidence, because reading the whole research, although we have it available, it may be more accessible for us to have it the other way. Can you do that?
Indeed, sir.
Okay.
Mr. Abraham, a lot of your colleague has spoken a lot about the involvement of human rights groups in trying to hold these corporations to account. Is there anything that you would like to get? Much was led in that space, but is there anything you'd like to add to what was presented?
Okay. So here's the issue. So now we know that there was a debt, and we can argue whether from a legal point of view or from any other point of view, whether this debt should have been paid and been honoured by the current apartheid, very current new democratic regime. So from a legal point of view, the issue is as follows. From an international law point of view, there is little authority that debts that have been contracted by despotic regimes, any subsequent state is not obliged to honor those debts. Now this is contested, and then there is a lot of legal support in favor, there's a lot of legal support against it. I was confronted with the very same issue as to whether, from an international law point of view, whether whether the new democratic government was legally obliged to honor those debts. One of the problems with international law, it deals with states. And the argument was made that what happened in South Africa was not a state succession, but a mere governmental succession. I argued the contrary. I said that, in fact, the transition that took place was more than just a mere governmental succession. It may not have resulted in the fragmentation of another state being formed, but it was a completely new regime that took over from a criminal one. And in that respect, it cannot be that the debts of the former apartheid government could automatically have been subsumed. Now, but in order for anyone to raise a defense and to raise the issue of that the debt ought not to have been paid, principally would have had to be the new South African government. And so in that context, a 4 or 5 year long campaign had been waged by the South African chapter of the Jubilee 2000 movement. We did it become known as the Jubilee South Africa. And that campaign was both a local, domestic and an international campaign aimed at getting both the South African government to repudiate, and on the other side, to get those corporations to voluntarily write off those debts as an act of reparation towards the people of South Africa. That failed. And it is in that context that the question was then asked, what next? The South African government was quite clear, and Mr. Trevor Manuel, then Finance Minister, was on record to say that if there was a debt, that foreign debt was, I think, 5%, if not less, of GDP, or of the overall debt, and it was certainly not worth the while. Our view was that the young democratic government was too eager to show and prove to the international capital markets that they can and they are in charge of the economy, and that they were perhaps hesitant to alienate the capital markets. And this is how the story of the Kulumani litigation then came about. And the Kulumani litigation would say, fine, if the South African government is then not prepared to take that first step, then we should be looking at how we can hold these corporations, to whom principally these debts will be owed to, liable for their involvement in extending loans to the apartheid regime. The problem, though, is that if you go into the arena of law, you can only do so in terms of what the law provides. And what the law provided at the time, the jurisdiction that was available was in the United States. But now what happens is that the argument then moved away from odious debt into the realm of individual liability. So I think in light of what member Yakub had raised, I thought it's important to contextualize that whereas we understand that there was a debt, whereas we are, you believe that the debt had come about, in ways of propping up the regime. From a legal point of view, in the absence of the South African government being, unwilling, having been unwilling, the new regime, to either unilaterally not honor those debts, in the absence of it, the closest that civil society could get was in respect of what was available at the time. And what was available was the narrowness of what the law could provide in the form of the alien tort, statute. And Marjorie Jobson had spoken quite a bit, but the alien tort statute essentially provided for a forum where if an international law violation had taken place, wherever it might have taken place, an alien, i.e. a non-US national, could come to the United States, and if that national, and if that entity is found on the soil of the United States, then that entity could be held liable. And this statute has its origin in the early 1700s, or the mid to late 1700s. And it was the attempt at stemming the slave trade. Because what has happened is that both the slave trade as well as the piracy, because what has happened was that because of the frequent routes between Europe and the United States, the piracy was rife, and essentially the act was aimed at, once those pirates were found on the shores of the United States, those aliens who had come from the United States and were not US citizens could proceed with litigation. I'm not going to go into, all, because March is late, the foundation. But I'd like to say, just from, being, an attorney myself and being, involved in this kind of litigation for most of my life, when we seek to litigate an aspect which, in this particular case, which essentially, as you say, starting from a situation where we had a debt, which certainly from legal, political, and very well from a moral point of view should never have been on it, it becomes difficult, almost impossible, then at the end of, when we begin to embark on a journey of litigation, to think that we will achieve the very same outcome that we envisage in terms of the bigger ideal. So essentially, as I say, that the litigation narrows down to those little areas of civil and political rights, holding them liable under the banner of, or under the legal basis of third-party liability. Just in a snapshot, that litigation had been an arduous one. And I'd maybe like to just reference individuals involved in the litigation. We refer to the litigation as the Kilimani litigation and the Ntsabesi litigation, the Kumaji. But behind them were our people, individuals, those who have been tortured, who have been sexually violated, those who have suffered arbitrary detention. And if we look at the context and within which and how, their own personal stories, what we sought to do is to make the connection to the very same corporations that provided the arms and the ammunition, that provided the finance. Because South Africa, apartheid South Africa, was an enabling environment. It was great to do business, even at the expense of cheating, compulsory, embargoes. And so I think the litigation should be, conceived in that context. And it's regrettable, we have managed to secure at least $1.5 million extracted out of General Motors in the time of its bankruptcy. But unfortunately, the South African government has been opposed the biggest opposition to the litigation. And in the end, other than that, we also had the US Supreme Court that had ultimately sounded the death knell to the litigation.
Your narrative mentions that the South African government was opposed to the litigation. Was opposed to the litigation primarily because of what the then Minister of Finance said, that the debt was only 5% of GDP and the country was insufficiently in control of its economics, or was there another reason why you think the government was opposed?
There may be part of that, but principally, and I think my colleague, Ademison Spencer, will speak about this. The government felt that its rationale was the Truth and Reconciliation Commission process. It felt that the Truth and Reconciliation Commission process had definitively dealt with the issue of liability. Our position was clearly, frankly, no, not in respect of corporate entities. And I think my colleague will speak about this. The ambit of the Truth and Reconciliation Commission was in respect of individual perpetrators who would come in exchange for, telling their story truthfully, they would receive amnesty. But the ambit of the Truth and Reconciliation didn't extend to corporate entities, notwithstanding the fact that the Truth and Reconciliation Commission had hearings, but as part of its evidence gathering process. So we believe that was misplaced. But more importantly, the South African government, it found a declaration called, which we infamously dubbed the Maduna Declaration, then Minister of Justice, basically said that, look, through our entire reconstruction and development effort, and through the economic plan and approach and the policies that we believe that this litigation is contrary to our intention. And our plans, we have made significant progress, and they believe that for this litigation should proceed to it, much needed foreign investment will be lost to the country. So that was, we of course, in respect of each of those arguments, we made the point very, very clear that there was absolutely no basis. But I mean, if there is a specific request to deal with that, I will.
And so the litigation itself was, as you say, not really successful, but for the $15 million that you were able to get from General Motors. 1.5.
Yes.
And as by way of parting words, what were the lessons learned by or through this litigation, perhaps?
I think the very important lessons learned is one, and very broadly speaking, and in no order of sequence. I want to start off with more the non-legal. The TRC, as much as the TRC has played very important role, I think the TRC's mandate was wholly insufficient insofar as dealing with the issues emanating from our apartheid history. More particularly the issue around the economic crimes that have been committed in the country. Now, what we've seen with other TRCs subsequently is that they have included aspects of economic crimes. South Africa's one was narrowly focused on civil and political rights, and I think that is one of the biggest drawbacks on the South African experience. Two, I think that a lot of the recommendations made by the TRC should be revisited, quite frankly. And I think that's maybe something for my colleague or the others to take further. But more importantly is the issue of litigation, because when we litigate in this kind of space, it is when we have considered a number of alternatives. Because trying to litigate matters that are very broad, policy-laden, etc., they're very difficult when you start funneling them through the court. And I think, and maybe this is where I'd like to say that I'm currently involved in one of the largest litigation in the United States, in South Africa, around mine workers who contracted occupational lung disease, the largest class action. But if one looks at that, the origin of that stemmed from one of the biggest injustices that could have been done to this country, which is the migrant labor system. And by challenging the migrant labor system in the form of, we deal with a certain aspect, but it does not still deal with the structural issues that still persist to today. And so litigation can play a role, but it is not necessarily the answer to all of the issues that we confront in this space.
Thank you, Mr. Abrams.
Thank you.
Okay, thank you very much, the panel.
Thank you very much, Mr. Abrams. I just wanted to ask a question in relation to the opposition by the South African government to the litigation cases, whether there was not an issue of sovereignty and the issue of national development, and basically an outsourcing of our development path to what were sort of foreign courts, the issue of sovereignty.
That's a very good question, being asked in the secretary. Regrettably, but that's not the issue before the court. So the government raised the fundamental issue of development, sovereignty, and so on. Now, if one looks at what was before the court, those were the very narrow issues in respect of which we sought to hold those corporate actors liable on the basis of complicity. So if we say that the Truth and Reconciliation Commission did not provide any form of amnesty to corporate entities, whether they be domestic or foreign, that means to say that anyone who could prove and show that he or she has suffered a harm as a result of the complicity, albeit secondary complicity, of these corporate entities, certainly should have a right. Unless that right has expressly been taken away from them, and in return for that being taken away from them, they had received compensation. Now, the only instance of that is what the TRC provided for. For truth-telling, amnesty will be granted, but in exchange, those victims being identified, individual victims identified, will receive compensation, because they will not be able then to pursue their claims, civilly or criminally, against those perpetrators. The corporate entities don't fall into that bracket.
Thank you, Mr. Abrams. Just another quick questions. You mentioned a number of resolutions that were taken by the UN. Would you just maybe mention some of the corporations, particularly in the armaments industry, that went against some of the sanctions?
So my colleague, Ms. Marjorie Jobson, planned 2 corporations. And if we need more of that, we're quite happy to put that information before the tribunal. They would, for instance, be Rheinmetall. So what is interesting about Rheinmetall was, as my colleague referred to, is that post the 77 embargo, compulsory embargo, it procured fraudulent arms exportation documentation meant for South Africa, but it first got the exportation documentation in Germany for the purpose of exporting an entire arms and munitions plant to Paraguay. It got that. Once it landed in Paraguay, that very same shipment got rerouted and ended up in South Africa. And so there was an inquiry. They've been found, fined. But, of course, I think, March has, responded to that in, very particular terms. But we can quite happy to flag that as an instance of the compulsory violation of the arms embargo. And there are other instances of, for instance, Ulicon Contradas, being the Swiss company, that had done the same. And so we've got quite a bit of, information. We've got evidence on that. And more importantly, we can also provide the contrary evidence in terms of what has been the response of these corporate entities in respect, thereof. But they are there, and we can certainly provide it. Because those are instances of specific violations of not the voluntary embargoes of the United Nations General Assembly, but the compulsory arms embargo.
Thank you.
Oh, Mayor, yeah. Well, thank you for your presentation. It's rather bleak that the road to litigation has come to a stop in the U.S., and I'm aware of the U.S. Supreme Court case in the Shell company that you can no longer claim against companies under this aliens procedure. I would like your comment on how was it achieved in the UK compensating the Mau Mau freedom fighters after such a lengthy period? Was that litigation or civil society pressure? That was one aspect. And also, would you comment on what Dr. Jobson said about doors being closed to victims here by the TRC's prescriptive period in which they could access justice? And can that be challenged in litigation in the South African courts here?
Thank you so much, Member Pillay, for the question. So if you would indulge me, in respect of your first question, I would have wanted to give you much more considered response, but I will, from my own understanding. That litigation has principally come about through the interaction of both civil society, but very, very, very targeted litigation that had been undertaken by, in fact, our colleagues in the United States doing very much in the United Kingdom doing the same work. Those, in fact, I would want to just say that we would certainly like to look at, because it specifically targeted the United Kingdom, per se. Sorry. In the context of South Africa, we had initially looked at whether the same kind of procedure could be adopted. One of our big difficulties is that we dealt with a very young democracy. And given that the South African regime had now, the apartheid regime had come to an end with a new regime. Now, we made the argument that the liabilities, at least the financial liabilities, could never have been transferred. If we make the argument, should the same then be say that all the liabilities, all the obligations that the former regime had. Now, there were a lot of potential civil liabilities which the apartheid regime had, that had now been transferred to the new regime. And so it created the difficulty for us strategically as to whether we should potentially look at pursuing this litigation against a young democracy. We decided not to. But I want to come back then to the issue of what has come out of the TRC. On the issue of prescription, now, the basic rule of prescription is that you can only pursue your claim if you know your debtor. So if you know your debtor and you know exactly what your cause of action is, well, in fact, you know your debtor, you know the identity, and so on. A lot of this could never have been known, could not have been known, had it not been for the TRC. But the problem is that insofar as it concerns corporate entities, not enough has come out. And so I believe personally that there is still a potential, there is still possibility. Because as we are unearthing more and more in the form of the work that Henny van Vuren, for instance, has done, I believe that this creates, possibilities. Not just, and I believe that, the opportunity in the United States is gone, but I believe it creates opportunities within South Africa for those who are dedicated enough and prepared to consider them. So I think that there is an opportunity, and I think so forums like this, they are important, because it has the potential of, bringing, more. And so as far as the issue of prescription, I'm not too worried, about that.
Thank you. I have some questions. So, of course, you've heard what I said to the other witnesses and evidence leaders about the need for summaries and evidential material, and I don't need to repeat that with you, right?
Yes, indeed.
Right. I do have some questions, though. And again, we don't have to be neutral umpires and stay away from the arena, even in ordinary criminal trials, but even here we have the liberty. So I want to raise some issues with you. First is that there was an allegation in a book by, I think it was the editor or the first editor of the Mail and Guardian, who is now a legal academic, media academic of note, who made the allegation that a member of the apartheid regime had salted away money in a Swiss bank, which amounted to some millions years and years ago, and that his effort to persuade the current government to recover that money failed. Do you know anything about that?
So, perhaps not the very specific case, but I know of the attempts at tracing money that had left the country on the eve of the transition, full scale, and that in fact is the basis of the CIX, report. I know that there has been attempts, that have been, made, and in fact some of my colleagues have been quite at the forefront, to look at what we could possibly do to, initiate a, process, of, tracking and tracing. The problem though is a lot of this very much depends on the credibility of the information that, comes to the fore. There is what I believe, some that we have, in the public domain. But then the issue becomes who ought to be either the party, i.e. the state, i.e. civil society, i.e. particular named, individuals, to take that, process forward. The issue then becomes, if the monies, are in a Swiss bank, would that be the appropriate forum then that we would, initiate, those proceedings? And would the, allow us the opportunity, would Swiss, law provide us, the opportunity either in the form of civil society or, specific named individuals? So let me just then, make the point. Litigating in this space is the following. To a great extent, we rely on the information that comes forward from civil society. We consider that information. We look at it. We have a network of lawyers spanning across the globe that do this kind of work. We engage. But to the extent that it is possible, we do undertake them. But the importance of undertaking this kind of litigation is not that the litigation is self-standing. This litigation needs to always take place in the context of a much broader campaign. Because without that campaign support, that litigation can fade into oblivion.
Okay.
May I have a follow-up question to that, Chair?
Yeah.
So now we have the AU taking up a position of illicit financial flows. You've seen the extensive report chaired by President Mbeki, who was the president when the litigation was obstructed. And they're very concerned, aren't they, on now tracing these illicit financial flows because they're to the tune of 90 billion a year out of Africa, far in excess of the aid that Africa receives, and asking the developed countries to lift financial secrecy laws of banks. So would you see that as an opening for civil society to take up these challenges?
Most definitely. So, when this came to the fore, Zambia was in fact, the country that was highlighted, where a significant, sum of, foreign exchange, in fact, illicit flows, taken place. And so we had already, started to talk, among ourselves and said that, look, we could, because the parties have been identified, and we, in fact, wanted to make the suggestion that we could certainly provide the necessary support and expertise to the Zambian government to be able to engage in an attempt at trying to have those monies repatriated. So I certainly believe, and I think that this, quite frankly, I think it's a great opportunity. More importantly, because we increasingly begin to see the interaction between, in fact, it's been there for a while, of civil society and lawyers, law firms, who operate and who are engaged in these kinds of matters. And it's not, and there is a network of lawyers, out there that can push back, that can provide, states. But I think that there is still this, hesitance because it's new. But I think in a very incremental way, if, states are prepared to open up and, prepared to consider, embarking on, even if it's what I would call very targeted experimental, litigation. And this has happened in the case of vulture funds, where a lot of, those who had, bonds and the bonds been floated, etc., where they couldn't, pay, in Zambia being the case in point, it's been taken, to court in New York, etc. We have always believed that that was an opportunity because states, unfortunately, sometimes also lack the capacity from, a legal and knowledge point of view to be able to come up with, pushback, in, these fora, and so on. So there are opportunity, but I think it needs to be targeted, and, I think, it's those are certainly things that one can look at.
I have a few more questions. I wanted to ask colleagues and the people who are here, just give me an indication in some ways, and one of my colleagues will announce it to me. It may take another 10 minutes. Shall we finish with Mr. Abrams, or shall we take the adjournment now and come back?
We are finished with Mr. Abrams.
Thank you. Mr. Abrams, a couple of questions. The first is, I'm sure you'll agree that customary international law, particularly in relation to crimes against humanity, has developed a great deal in the last 10 or 15 years. What is the learning on whether these developments in relation to crimes against humanity are retrospective or not? And I ask this question because if the courts develop the common law in most parts of the world, those developments are retrospective. Do you have a view on that?
Yeah, there comes a point where one also has to say that
Sorry?
there comes a point where one has to concede and have to say that if you haven't considered the argument, then you would not want to venture out, in making the argument. No, I don't have a particular view, on that. I know that, the argument is out there. In fact, I thought, and if I may, use, or if not abuse, the opportunity, I thought that the question that perhaps you would have, wanted is the applicability of key norms, recognized norms under international law and its applicability to corporate entities.
If you feel inclined to give something to us in writing about this, I personally would appreciate it
I
a
would
great
certainly.
deal. Then the next question is, you see, in our constitution, the problem is, you said this government has no responsibility of what apartheid government did, and yet we have to see the government's responsibility through the prism of the constitution, which places certain obligations upon government in relation to improving the quality of life, and all these things are supposed to be considered in terms of international law. I wonder whether you or someone might just consider, and you don't have to answer it now, let us know whether on a proper construction of the Constitution, because that is what is missing in our evaluation, read with customary international law, which of course, as you know, is binding on our country, unless an act of parliament or the Constitution provides otherwise in terms of section 233. Whether there is an argument that this government is obliged to go some way in terms of our constitution read with customary international law. I just wanted to know whether you want to comment on that now, or shall we leave it later for a considered view?
So perhaps if you could just, perhaps maybe, contract, the point in simple term, the government's obligation under customary international law vis-a-vis what? And my apologies for the retort, Member Yakub.
Okay. Then also we should bear in mind, I suppose, the provisions of section 35(3)(L) of our Constitution, which effectively says that we can't make new crimes.
Yes.
But if there were crimes under international law at the time when they were committed, then we can make new crimes. And maybe we need to give consideration to whether or not there should be a recommendation that certain international law offenses at the time should be made crimes now because the Constitution allows it. And I wonder whether that question too could be considered.
Member Yakub, may I very broadly, perhaps just respond to that in saying that we know that South Africa adopted the view of what they called the persistent objector to the applicability of international law, whether that be treaty or customary law within its domestic law. And we've seen a number of some of those cases where judges errantly basically adopted that view. The fact of the matter is that there are certain norms under international law, and I may just very broadly refer to them as those Hughes Kogan's norms, whether South Africa being a persistent objector or not, those norms were applicable to the South African regime by virtue of customary international law. And so I certainly believe that there is a case to be made that was law, albeit customary international law, even under apartheid. And stemming then from there, I believe that we could make the argument, and if well considered, that notwithstanding South Africa's persistent objection to the application of international law when it suits it, that was indeed the law, and as such, we could, within a domestic context, make the argument and create a basis, whether in criminal or in civil law, for potential liability. But I think we need to develop that argument, we need to explore it, and we need to develop it further, and perhaps come to you and make recommendations around that particular aspect.
And you will expand your written submission accordingly.
Yes.
And you'll be relieved to know that I'm through.
We'll.
Any other questions arising?
No?
Okay, thank you very much. We may now refuel in any way we think appropriate and return in an hour. Thank you very much.